Rise for the District State of Florida is now in session. Now, take it to be in mind for the Chief Judge presiding. We're saying this is for your attention and you shall be heard. The God save the United States of America, the state of Florida, and this Honorable Court. You may be seated.
Good morning and welcome to a session of the 5th District Court of Appeals. As you heard, my name is David Monaco. I have the privilege of being the Chief Judge of this court. To my right is Judge Thomas Soroya. To my left is Judge Richard Orfinger. We are the panel considering the 3 cases that are before us today. Before we get started, let me remind everyone that these proceedings are being videotaped and are being streamed online. And we have very good acoustics in this room, so if clients are talking to their lawyers, you might find that information broadcast on air, so be careful about the tone of your voice and the elevation of your voice. With that in mind, let's see, we have 1 criminal and 2 civil cases today. Criminal cases get 15 minutes apiece. The civil cases get 20 minutes aside. And I will remind the appellants that if they want me to alert them to when any rebuttal time that they may wish to reserve it comes due, let me know and I'll try and do that for you. All right, let's get on with the first case then, Christian Felix versus State of Florida.
Good morning. My name is Susan Fagan and I represent Mr. Felix in this appeal. There are 2 issues in this appeal. The first issue is the trial court's denial of the motion to dismiss. By the way, I'd like to reserve 5 minutes for rebuttal.
Okay.
Thank you. What we have is the interplay between 3 subsections of Section 77515. We have subsection 5, 6, and 7. And even with the development of the case law cited in the briefs, the main focus is there a continuous absence by the defendant? And our first point of argument is that there wasn't a continuous absence of Mr. Felix.
What did the trial judge find?
The trial court found that subsection 6 applied, that there was an absence, and that there was a diligent search by the state, the law enforcement authorities.
Is that a factual determination?
Yes, it is.
And how does that come?
It's conflicted by the evidence and the testimony presented during the dismissal hearing, Your Honor.
But don't we have to find, in order to rule with you, would we not have to find an abuse of discretion?
There is, yes, that is the fact, that given the testimony and the facts in the record, it was an abuse of discretion by the trial court to so find.
And under Kanakers versus Kanakers, an abuse of discretion means that no other normal judge in the state would have come to the same conclusion.
That's correct, when faced with the facts in the record.
Okay, fine.
That's correct. And what we have here is, as I say, an offense date dating all the way back to 2001. And a misconception by the trial court that we go to the report date, which was moved up to 2004. Actually, the child turned 16 in 2003. So the report date is of 04 is a year too much. Secondly, as far as the diligence...
When you say a year too much, is it your contention that the clock should have started running when she turned 16?
That's correct. Because it's the subsection 7 of 77515-7 clearly states that it's the earlier of the report date or the date that the child turned 16. And we're, of course, going back to the statute as written in 2001 when the offense date occurred.
Well, so even if we use the 03 date when she turned 16, they issued a warrant or capias sometime as she reports it in 04, and I think they issued the capias or warrant then. Doesn't the inquiry at that point become whether or not your client was absent from the state during some or all of that period of time? And B, did the state make a reasonably diligent effort to ascertain his whereabouts and apprehend him? Does that really become the focus, even
Yes.
whether we use the 03 date as you contend or the
Yes.
04, whatever the date is, it really comes down to was he gone, which would have a tolling effect, and even if he wasn't gone, did the state make any effort to find him, a reasonable effort to find him during the applicable period?
Yes, that's exactly right. But we're focusing on the term in the statute of continuous absence as well. Because, as we say citing in the brief, the King case, way back, the basic tenet is that statute of limitations are liberally construed in the favor of the accused. And we have a burden clearly being established upon the state, not the defendant. And, of course, we got into the situation in the hearing, the dismissal hearing, about the Pearson case versus the Netherly case. And the real problem is that, and Judge Orfinger touched on the word, it's diligent search. And diligent search by the authorities has not been disputed by the court in Pearson. Pearson seems to focus on, quote, reasonableness and not apply it to subsection 6, which deals with the continuous absence of the defendant.
Well, when we look at it, seems to me that subsection 6 really has two alternative sections. One is continuous absence, and then it has an or has no reasonably ascertainable place of abode or work in the state. So presumably, if you're continuously absent under the first section, there's a tolling effect. Or B, even if you're in the state, if you have no ascertainable place of business or residence, there's a tolling effect.
Within the state.
Right, within the state. So
Correct.
It seems to me that one is out of the state, one is in the state. So let's focus on the first part of it for just a moment. In your view, is the idea to be continuously absent? For example, if I'm gone for a year from the state, and I come back for a weekend, and then I'm gone for another year, is it your contention that I would be continuously absent from the state for a year and then another year, or I'm not continuously absent at all because I popped in for a weekend? Or how do you construe the word continuous?
Well, we have clear testimony that Mr. Felix was in Florida well towards, I believe it was December of 2003. So our argument is that's not a continuous absence. When you go back to March.
So you think it has to be continuous during the entire period of limitations?
If it's construed, yes.
In other words, if I commit a crime today such that the statute would begin to run today, and I'm in Florida for 6 months, but then I leave and I'm gone for the next 4 years, is it your contention that because I was here for some period of the limitation, that I wasn't continuously absent?
Well, I guess again, we're talking about statutory interpretation, and literally sometime between her turning 16 in March of 2003 and December, that's a substantial time.
See, the problem I'm having is it seems to me that it's a tolling. It says it doesn't run during any time the defendant is continuously absent. So it seems to me that in my scenario, during the 6 months I was in Florida, it's running. When I leave Florida, it's tolled. And it seems to me that, again, a continuous absence, if I'm gone for a year, come back for a week, and then I'm gone for a year, it seems to me it's tolled during the year I'm gone. it runs during the week I'm back, unless it falls under the second provision of the statute, and then it's tolled again. And I'm just trying to understand how would you have us interpret the statute?
Well, given the facts, under this circumstance, we have not a continuous absence. More importantly, the trial court just basically applied the wrong start date as well, and just assumed that there was a continuous absence because he's moving it up, the trial court rather, is moving it up to 2004. But most importantly, the requirement of reasonableness and a diligent search by the authorities is still incumbent under subsection 6. That is our main contention. That we can look at interpretations of continuous absence and look at it, well, what is more favorable to the accused or not. But what we are faced with here are a few telephone record checks, the authorities saying that, well, I don't know if caller ID was available. They're taping phone calls from the aunt, and that is getting child support from Mr. Felix in New York. And when you look at the record, it just doesn't support a diligent search. The case of Miller, and particularly we have State v. Mack and Connell, which talk about what are reasonable areas. And we're saying that if you look at those areas identified in the decisions, that the state did not follow through. And there was definitely no follow-up of a diligent search. And thank you very much, and I'll reserve the remaining time for rebuttal.
Okay, you have about 4.5 minutes left.
Good morning. May it please the Court, I'm Assistant Attorney General Mary Jolly on behalf of the state. I agree to a certain extent with the factual assertions that Ms. Fagan has presented this morning. I do want to note to the Court that under the statute subsection 7, the statute of limitations does run on the earlier of two dates, the date of report or the date when the victim turned 16. And in this case, she turned 16 March 30th, 2003. So that's when the statute of limitations starts running under subsection 7. She didn't report the crime until February 2004. It's undisputed factually that the defendant left the state of Florida in December 2003. So to inure this continuous absence on the state of Florida when the crime hadn't even been reported until 3 months after he had left seems to be a little confusing to me. So I just wanted to clarify that in any obligation that would inure to the state can't even start until they've been made aware that a crime even happened, which happened 3 months after he left the state. Subsection 6 is a tolling provision. The case law is clear.
Wait a minute. Is it your suggestion then that the crime has to be reported for the statute of limitations to run?
No, I'm sorry. It's not. That's not my assertion. My assertion in terms of this continuous absence notion is that that didn't even happen. That started before it was even reported to the state. No, I'm not saying that. But clearly we don't disagree that it started 2003 and then he was gone. 4 months after that, he disappeared December 2003 and he was gone until he was arrested in 2007. Subsection 6 is a tolling provision. The case law is clear. That's what it is. Subsection 5, which is where all of this reasonable, diligent effort language comes from, is the actual statute that describes when a prosecution begins. And it's our position that Pearson is correct in that you don't read that diligent search effort language into subsection 6. It's not in there. So I think the conflict that the case law, Pearson out of the first says, no, we can't read it into subsection 6. Netherly out of the fifth reaches that conclusion by relying on cases, Miller in particular, that are addressing when a prosecution commences under subsection 5. There is a little distinction there, and I think the first DCA was correct in saying we're not going to read that requirement in. Judge Walsh, in an exercise of caution, did so below and made factual findings that are supported by the record. In terms of, he made factual findings that there were efforts made in an exercise of caution to protect himself, although he specifically found that the first DCA decision was more persuasive to him. So it's our position that we've covered it all below. But it's the state's position that it was, obviously, it started in 2003, but we are amenable, and the tolling provision does apply to us, that the statute was not expired by the time that he was charged in September 2007. And I asked this court to look at the two cases of Pearson and Netherling, and I think Pearson does have the appropriate analysis for purposes of subsection 6. And unless this court has any questions, we'd ask for you to affirm. Thank you.
Thank you, counsel. Ms. Fagan, you have 4.5 minutes.
Yes, Your Honor. Just in brief rebuttal, well, if the tolling statute is going to apply, but the diligent effort and reasonableness isn't going to apply, we can't pick and choose. So as far as applying that to subsection 7, I think you have to read reasonableness into the entire statute.
If we elect to follow Pearson, or if we say Pearson correctly states the law and that we don't go to subsection 5, what then is your position? You concede that you have a little argument here?
Well, no, because Pearson also requires a diligent effort.
All right, but if we say that we only look to the other two subsections, as opposing counsel has argued, what then is your position?
Well, the subsection 7, as again starting a new start date for the statute, would not then be applied to the tolling statute, as was one argument that we have. But again, you get back, this court can't escape the efforts, the lack of efforts, rather, and the lack of follow-up, that no matter which case law you look at, and tying in the constitutional speedy trial arguments in the case law cited, that, the reasonableness is a theme that is long established and still established in our both state and federal constitutions. And it must override a technical, mechanical tolling aspect of one subsection, which totally ignores what the state does in its efforts to actively pursue its prosecution. Again, we're talking a period of 2001 all the way to the arrest in 2007. And the overall weight of the record, it definitely tips towards unreasonableness, a lack of diligent search, and basically a lackluster effort to even pursue prosecution on the part of the state. And quickly, as to point 2, the Williams rule, this court's Fisk opinion, we would submit adequately.
Ma'am, you're in rebuttal.
Adequately addresses that issue. Thank you very much.
All right, thank you, counsel.